physically will see the change. I will see them at the start of the mediation, and they're in the fight, and they're so angry, and they really want to get justice. They want a fair result. And by the end, to get it settled, they are so much lighter. They are so much happier. But at the end of the day, we got it done. We got a settlement on both of those cases.
Fantastic.
So the case that was supposed to go to trial, that didn't go to trial, that got resolved. The attorneys saved their weekend. They probably would have spent all weekend preparing for trial. Didn't have to do that. Really do believe in the value of mediation. And we want to make sure it doesn't develop a bad reputation as something that's ineffective, that's a waste of time. That's what we don't want. And so I think we're very careful to do a good job and try to make sure the parties are satisfied, even if the case doesn't settle, that they're at least satisfied with the process.
So hi, welcome to another episode of the SMC podcast, which we lovingly call Mediators Talk, where we have accomplished mediators joining us from all over the world, talking about their experiences as mediators, talking about the special things that they have done in their respective areas. So today, again, we have a very special guest, Mr. Jason Cairns, who was my batchmate in the Harvard Law School program on negotiations. And I'm so happy that we could reconnect over here through this platform, and we are having this podcast. Mr. Jason is a full-time commercial mediator based in Austin, Texas, that is United States. He specializes in insurance coverage disputes and mediates all types of civil cases. As a litigator, Jason handled complex commercial cases at Sidley Austin LLP and King & Spalding LLP before becoming a partner at Reed Collins and Sy LLP. Did I pronounce it correctly, Jason?
You did. That's right.
Okay, great. One of the top plaintiff side litigation firms in the country. His practice focused on insurance coverage disputes, and this is something that we are going to talk at great length today because this is his specialization area as well. Jason has represented clients in state and federal courts across the country at both the trial and appellate levels. He is the alumnus of Case Western Reserve University and Northwestern University School of Law, where he also served as the editorial board of the Northwestern University Law Review. Traditionally, we start with the stories of the guests that we have. What got you started in mediation in general? What was the idea that really, appealed to you? A little bit about yourself, Jason. It would be a great starter, I think.
Sure. So I was first introduced to mediation when the summer after my 1L year of law school, and I externed for a federal magistrate judge on the Northern District of Illinois, so in Chicago, which is where I was in law school. It was Judge Susan E. Cox, so I was an extern. And as a magistrate judge, she also did some mediations, and she allowed her externs to sit in and observe those mediations. So that was my first exposure to mediations and like what it was, at least, what it is in the civil litigation context. So that really piqued my interest, very early on in law school. I went into civil litigation, but I'd always had in the back of my mind mediation. And I just a few years into practice, I bought a book, actually. It was called Becoming a Mediator by Peter Lovenheim. He provides very frank advice about what it means to be a mediator as a business, how you get started, the benefits, the challenges of, actually running a business as a mediator. So I read that just a few years into my, litigation career, again, thinking that, maybe one day I would want to go off and become a mediator. But at that point, I was still very much enjoying litigation, being a litigator. I was still in that world. Later on in my career, I eventually just hit a point where I wasn't enjoying the work of litigation like I used to. Litigators, lawyers, we work a lot. So I was spending a lot of time doing work I really didn't enjoy very much anymore. And I found I'd also been, I was growing tired of being in the adversarial mindset. Where you're constantly feeling like you're in battle with other attorneys, day in and day out. And I found that I would be carrying that adversarial mindset and kind of thinking about that fight, even when I wasn't, technically working, if I was, washing dishes, doing it was just always kind of in the back of my mind. So it's kind of carrying stress with me, which I know from talking with other litigators, they do that too. That, when you're in a fight, you have a hard time kind of letting it go or kind of separating. Some litigators probably do it better than others, being able to separate those two sides. But for me, I was carrying it around with me a lot, and I didn't want to have that adversarial mindset being that so often. And so I knew I needed to make a career change. And I had mediation in the back of my mind for a long time. And so I thought, well, why not now? Why not go for it? And so that's what I did. I left litigation, made the plunge, and to start my own mediation practice. And here I am.
I think this is inspiring, Jason, because it is not easy to, usually litigation is seen as much more lucrative than a regular mediation practice. I don't know how it is in the US. At least in India,
Sure.
Litigation is seen as something where you can make a lot of money, but mediation is not seen with that lens. The fact that out of your own inner calling, you chose mediation over litigation because you thought that maybe you had more interest towards the collaboration side of it rather than the adversarial side of it. I think it's an amazing thing that you have shared. And I'm sure that it would give courage to a lot of potential mediators in India also, because there are a lot of people who are exactly in the stage where you were before, and they are not satisfied with the way litigation is happening. Courts are overwhelmed. It is more of a formality. They're just managing clients. How did insurance mediation happen? Because I believe that is your specialization area. So what were the reasons that you picked this area specifically?
Sure. So, when I was starting my mediation practice, I did a lot of, reading about, what's the best way to launch a practice? How do you market your practice? Because as any full-time mediator will tell you, it's a business. You are running a business, and you need to think of it as a business. And so I knew it was best to kind of develop to focus on one area, have a niche area, so that I could, focus my time and energy on bringing in those kinds of cases and developing that specialty. And insurance coverage cases, litigation was one of my primary practice areas when I was a litigator. And so I already had that background knowledge. I already had that experience. I also, from an intellectual standpoint, I always thought insurance, cases can be very interesting. Legally, you're dealing with contract law, tort law, you have statutory claims, there's obviously the fact patterns, there's all different kinds of insurance and all different kinds of disputes that can arise out of all the different types of insurance policies there are. So there's a lot of, diversity of cases that you can see within that practice area. And then also, practically speaking, it was a niche area that I thought I could make a living in as a mediator, right? There is insurance touches on, all aspects of our lives. Most people have multiple types of insurance. There is no shortage of insurance disputes in the US, at least.
Absolutely.
And there's tons of law firms and lawyers who spend their entire career just doing insurance coverage cases. So for me, it was a combination of, I thought it was interesting subject matter. I had experience in it, and it was a niche enough area for me to build a practice off of, but also not so niche that there wasn't enough work for me to actually, get cases. That was my calculus.
Did you pursue any course in insurance law as such, or your past experience was helpful in?
When I was in law school?
Yes.
When I was in law school, no, I didn't take any insurance courses in law school. I knew I wanted to do civil litigation, but at that point, I didn't have a specialty practice in mind. And when I first started at Sidley Austin, my first firm, I was in a general litigation practice, and so I was doing all kinds of all kinds of cases. Like as a litigator, I've litigated, like the breadth of cases you could do. I did white collar investigations, and then as I progressed in my career, I started to focus on a niche litigation practice, or on insurance cases later on.
What makes settlement in insurance matters very important to the parties in conflict? How do they feel once you have settled their matters? Or even if they have not settled, how does it work out for them?
Sure. So as a practical matter, for an insurance coverage dispute, right? Normally it's the insured versus the insurer.
Mm-hmm.
Um, and from a practical matter, the insured who's often bringing the case, they often need that money
Mm-hmm.
to continue on with their life.
Yes.
You talk about a person, if you're in a car accident, you
Hmm.
rely on that car to
True.
get to work and drive your kids around. And there's a lot of people, they need that insurance money. If there's a big dispute about how much you're supposed to get paid, they might really need that insurance money to repair
Yeah.
their car for the very practical reason of they need to be able to get
Right.
around and continue their life.
Right. Right.
Businesses, if your business catches on fire and your business
Mm-hmm.
burns down or burns a large portion of it, and you need to rebuild that business
We need
in order
something to
to
make up for the loss. Yes.
yeah, and then
Yes.
and then you're in a fight like with the insurance company over the money. You need that money
Hmm.
to rebuild that business so you can get back to making money again. And so there, for
True.
a lot of insurance, it's a very practical reason of they need to, they really do need those insurance proceeds to continue on with their life. So for those parties, they have a very big incentive in that realm. Practically speaking, when these parties settle, these insurance cases, like a lot of cases, these cases last for years. These
Mm-hmm.
these these cases can drag on for years, and by the time they reach mediation, a lot these parties are
Already
exhausted.
exhausted. Mm-hmm.
They're worn out with it. They're tired of dealing with it. They're tired with the stress. They really want to get a good result, but there's a level of, they just really want to be done with it. And so at the end, if the case settles at the end of the mediation, you know, I physically will see the change. I will see them at the start of the mediation, and they're in the fight, and they're so angry, and they really want to get justice. They want a fair result. And by the
Mm-hmm.
end, to get it settled, they are so much lighter. They are so much happier.
Right.
And giving them that sense of finality that this dispute is over. It's done. A signed binding settlement agreement, and knowing that they can move on with their life.
Right.
They're like you can just see the joy, the happiness.
That's true.
They're so happy to be done.
Any particular instances that you remember which really you would find worth sharing, and also any failures, just in case if something did not work out in mediation. And also, I'm sure that in our case, whenever mediation fails, that is also a teacher for us, because then we try to analyze that what went wrong, and we try to
Mhm.
get that better.
I can definitely talk about both their success and a failure that didn't work out
Hmm.
as well. Let's talk about the success.
Yes.
So I had a case. It was an insurance coverage dispute. It was about theft of business merchandise. A business had a robbery and lost a lot of the merchandise, so they were seeking their insurance benefits. There's a dispute. The insurance company thought that the employee might have basically been in on it, that they assisted the thieves, and that triggered an exclusion of the policy that would say, if you're basically colluding with the robbery, then we're obviously not going to pay you
Mm.
benefits for that. There's no coverage. And when the parties reached out, that was the case. They wanted me to mediate. Trial was right around the corner. It was a case that we were scheduled. I think we were scheduled to mediate it on a Wednesday, and trial was
Okay.
that following Monday. So trial
Okay.
was just a few days away. The day before the mediation, I normally hold pre-mediation conference calls with the
Right.
attorneys, talk to each
Mhm.
one-on-one, just to get their just to talk about background. Um, uh, so that way, when the mediation starts the next morning,
Mhm.
we can hit the ground running, talking about the substance of the case, the merits of the case. So, and during these pre-mediation conference calls, I learned from one of the parties that there was another dispute between that same insured and that same insurance company, also for a robbery, but for a different robbery, a robbery that happened years later.
Mm-hmm.
In that case, there was that in that second robbery, there wasn't a question of whether or not the employees were in on it. There wasn't a dispute about that, but I think the
Okay.
parties were disputing like the amount of coverage.
Mm-hmm.
And I learned from one of the parties, they were saying, hey, it would be great if we could also mediate this second case as well at the same time as we're mediating
Right.
this case that's about to go to trial. This
Great.
They're like, great if we could do that because we're already going to be here. Can we also try to get this
True.
done?
True.
And so at mediation, I brought that up. It was the insurance company that had originally brought up, could we maybe mediate both of these? And I brought that up with the insured, and there was originally some hesitation because that second robbery, that case wasn't as fully developed. It
Okay.
was as the first case. The parties
Mm-hmm.
basically they didn't have their minds wrapped around it. They hadn't.
Mm-hmm.
I don't think a lawsuit had even been filed yet. And it like the parties were in dispute, but I don't think a lawsuit had been filed. And the plaintiff they hadn't done all the work to really get their damages model in line.
Right.
They neither of the parties were as up to speed on the facts or the defenses. It just wasn't the case wasn't very developed. And so there was a little bit of
Right.
hesitation saying, can we even mediate this
Yeah.
now, given that it's not like we just simply don't know as much about it. And
Right.
I certainly didn't know as much about it because I only know what the parties can tell me, and the parties themselves
They were not
weren't up to
sure
speed.
about it. Yeah.
So there was a little bit of hesitation about like, can we do this? But both of the parties were generally open to it.
Mm-hmm.
Um, and so we went for it. It was for me, it was a little bit challenging to think about how do I help these parties? How do we mediate and negotiate two cases at once
Okay.
when these cases aren't related? They're not
Okay.
related factually. The only difference is that the parties are the same. But there was the parties, they had a willingness to negotiate and to let the mediation process play out on both of those cases, which is
Right.
frankly probably the most important part. If they weren't willing to do it, you can't force them. And so we found a way to discuss both cases at the same time, and that mediation, it was 9 hours. It was a 9-hour mediation, but at the end of the day, we got it done. We got a settlement on both of
Oh,
those
great.
cases.
Fantastic.
So the case that was supposed to go to trial,
Mm-hmm.
that didn't go to trial, that got resolved. The attorneys saved their weekend. They probably would have spent all weekend preparing for trial. Didn't have to do that. And then this
Right.
new case they probably would have, filed a lawsuit about it and, went to the races on it. We were able to take care of that one as well.
So, thank you, Jason, for that. Any other incidents where you think that it could have been better, or some lessons from there?
Yes. Um, so I had, so this was another insurance coverage case.
Mm-hmm.
Not a very complicated case. A tree branch falls on
Mm-hmm.
a roof, damages the roof. The homeowner seeks coverage for the damaged roof. Pretty simple. It was a pro se litigant against the insurance company. The insurance company came to mediation with the spirit to settle, wanting to pay a settlement and let this dispute go. The challenging part was this was a pro se litigant who basically had unrealistic expectations
Mm-hmm.
about what he was entitled to,
Okay.
what the law provided to him, what the law
Mm.
said. He was an immigrant to the United States,
Okay.
so English wasn't his
Okay.
first
First
language. He
language.
spoke English, but it wasn't his
Mm.
first language, and so there's a little bit of cultural um, differences between and there's also a little bit of a language barrier, not a big one, but
Mm-hmm.
there's that difference which makes it a little bit more challenging in a mediation. But the biggest thing was he did not have legal counsel advising him on really what the law says and what he
Mm.
could realistically get or what he could realistically achieve at trial. So he just had sky high expectations. And
Mm.
so the challenging thing for me was, as a mediator, as you know, we're not allowed to provide legal advice to
True.
to either party, right? It's very important that we
True.
maintain neutral. We're not
Right.
attorneys for either side. I was having this conversation with him, trying to walk that line of having a conversation about the case, about the strengths and weaknesses of his case, without providing legal advice and basically correcting him
Right.
when he was misrepresenting
Hmm.
the law. And
Yes. So you
so,
had that difficult job of giving him good advice without sounding evaluative.
yes,
Yes. Hmm.
and so it's one of these things where I think the case didn't settle. I think it very much could have been a case that the case should have settled. It was a case that was ripe for settlement, but obviously, the only way for a case to settle is when the two parties their kind of settlement zones overlap. When they both have when they're both able to see the same situation in roughly the same way to an extent. It was just so unrealistic what he was asking for that the insurance
Hmm.
company, he was asking for just a ton of money. The insurance company was like, "There's no way we would ever pay this amount of money. It's way beyond what he could ever get at trial. He's not entitled to it." And I just had a hard time getting through to him, given my limitations, as a mediator, to respect neutrality, not be his attorney. And so that is a case that is kind of stuck with me a little bit because I don't, every once in a while I think about it, it's like, could I have done something different to get through to him? Like, how would I get through to someone in that situation without breaching my duty of neutrality, basically?
Could you
So
come
that
to
was
an
a
answer
challenge.
for that? I mean, could you get an
Sorry.
answer for that?
No, when I think about it, I do not have an answer for that. I mean, I really feel like I did everything I could at that mediation to get through to them without breaching neutrality. But at the same time, it was a frustrating experience I mean, basically for everyone involved. The pro se litigant was frustrated because he believed, like it was a genuine belief, he believed he was entitled to X amount of dollars. And so he was frustrated that the insurance company wouldn't pay that. The insurance company is frustrated because they wanted to settle the case, but they were like, we'll pay a reasonable amount, but we cannot pay, five, six times what he could ever get a trial.
Hmm.
And so they were frustrated. And of course, I'm frustrated because I see a case, I was like, oh, I would love to help get this settled, but
Right.
couldn't get the parties on the same page.
If someone wants to become an insurance mediator, what are the ABCs of that, and how much of subject knowledge should an ex person have in order to really venture into this field? Uh,
Mhm.
does that person needs to be an expert, or is it okay to have a fundamental subject knowledge but being sound in the principles of mediation? That combination can work. So, if you can just throw some light on that, Jason.
Sure. So I don't think you need to be an expert
Mm-hmm.
in insurance law to mediate insurance coverage cases.
Mm-hmm.
As you know, if you have a foundation in mediation, you can mediate all kinds of cases. Most mediators do mediate all types of
True.
cases that I do not think they would hold
Mm-hmm.
themselves out as to be, you
Mm-hmm.
know, subject matter experts in. I think it's obviously very helpful to have a background in insurance litigation or be up to speed about terms that are used in insurance litigation, the law surrounding it. Obviously, it's very helpful because it's easier to understand the dispute. It's easier to get up to speed on the case. You
Mm-hmm.
know the terms of art that the attorneys are using, right? It's just like it's if you're an expert in employment law, it makes it easier to mediate
Right. To understand the
employment
nuances of
disputes.
it. Hmm.
Yeah. So it's certainly very
Helpful.
helpful, but
Hmm.
I don't think it's necessary
Mhm.
to be an expert in insurance law. I do think you need to be a lawyer with a background in civil litigation, right?
Mhm.
You need to have a basic understanding of the
Dispute.
law. You're right.
Hmm.
You need to have a basic understanding of contracts and torts. You need to understand how trials work
True.
because you need to be able to have enough of a foundation to understand what the dispute is about, of course, but also so much about mediation is talking about what happens if this case doesn't settle. What
Hmm.
does the trial look like? What do you
Hmm.
have to do to prepare for that trial? What evidence are you going to bring at that trial? How are you going to bring that evidence in? Like, do you have the witnesses for it? And so if you don't have a background as a civil litigator, I think it's hard to have a good deep discussion with the parties at mediation about that. But as long as you have a foundation in the law, a good solid, legal foundation, then the parties, normally provide you with the mediation brief ahead of time
Mm-hmm.
that should provide you with the relevant facts and law about the case you're going to mediate. You review that, you should be able to then just basically be able to get up to speed on the case
Mm-hmm.
from the materials that the parties provide you. And then if they provide you with anything, if you're reading through a mediation brief before a mediation and you don't understand something,
Mm-hmm.
then I think it's the responsibility of the mediator
Right.
to, do your own research,
True.
figure it out. Make sure that you are up to speed on the key
True.
issues, on the key cases, on the law, the statute, whatever it is. Make sure you're up to speed on that so you can hit the ground running at mediation. You don't want to be wasting time at mediation with having the parties educate you on with needing the parties to educate you on very
Right.
basic things, you know?
This would also help a lot of people who are somewhere skeptical whether they should explore the niche area or not, because I think it is more important to have the fundamentals of mediation in place. Rest of the things can be developed over and above the mediation training. So thank you for bringing up that, Jason. Coming back to the point where we were discussing your transition from a litigator to a mediator, in that transition period, what were the things that you made sure that would make you a successful mediator? I mean, how do you get access? How do you get referrals? How do you get clients? I mean, how does all of that work in your case as far as insurance is concerned? And in general, also maybe you can give some tips, especially to the early starters. I'm sure a lot of audience in India and abroad also would be really interested in knowing that.
Sure.
Yeah.
So, the first thing obviously is getting your mediation training. In the US, you're required to take a basic mediation training course.
Mhm.
Um, and so frankly, that's step one. So I really spent some time getting my mediation training
Right.
in,
Yes.
making sure I had good solid training. I also read a lot of articles. I would read articles online about, written by other mediators about tips for mediating. How do you prepare for mediation?
Right.
Um, Negotiating strategies. I was consuming a lot of information
Mhm.
on that sense. So that's the training aspect of it. Then you have to think about, really have to think about what's my business plan? What's my
Mhm.
brand? You know, what kind of work do I want to do? Who are my target clients? What are the kind of cases I want to mediate? Where am I going to mediate? Am I going to mediate in an office? Am I going to mediate virtually? Like you want to come up with a business plan
Mhm.
to really think through, like, how is this business going to work? How am I going to onboard clients? How am I going to have them pay me? How am I going to collect payment? Do I need to set up an LLC? And doing that kind of business foundation, creating a bank account, all the unglamorous things. Um,
Yes.
and then once you have that put together, then you have to think about, you brought it up, how do I bring in clients? How do I get the word out there? And
Right.
so, a website is critical.
Okay.
You have to have some sort of online presence,
Mm-hmm.
so people can find you. So when you say a media, they can like look you up and they can read about your background and your experience, and they say, "Oh, this guy does seem qualified. I do want to work with him." So you want to set up your website.
Mm-hmm.
LinkedIn is obviously probably the most common social media platforms that lawyers and mediators use. So you want to have a presence on LinkedIn. And then it's a matter of hitting the pavement and getting the word out there, which I think looks different for everyone depending on how far along they are in their career, what their network is. But it is if you've been a lawyer, of course, you can, network with your colleagues. So you can do that by, again, reaching out to your network, by going to conferences
Mm-hmm.
and networking in person, by joining professional organizations,
Right.
the American Bar Association, the State Bar of Texas. for insurance, at least there's a lot of professional organizations that are geared just towards
Right.
insurance lawyers that you could network with. But I think a lot of it eventually becomes developing really your reputation,
Hmm.
and then people know you and word of mouth. And someone, you mediate for an attorney, you do a good job, they like you, they then reach out to mediate with you again, or they refer you to someone else. I think that's
Yes.
that's what it becomes
Yes.
for a lot of mediators.
Right. So once you are in the mold, then it takes a snowball effect, keeps on rolling after that. So yes, thank you, Jason, for that. And I'm sure that there are many people who are at the nascent stage of starting their mediation practice, but they don't still muster the confidence to really take that leap of faith and get into that field. And these tips would be really helpful for them. Um, so, so the fact that you chose mediation over litigation, and the fact that you carved out your niche area in the form of insurance mediation, and you are much more satisfied now in the sense that you are, able to settle the matters between the parties. You see happy faces at the end of the day. Issues are getting resolved in a single day, and perhaps that is the magic of mediation. Well, insurance industry in general is growing everywhere. I am sure that it is growing in the US and India also. There is a lot of, in every single thing there is insurance, in railways and in air transport and in homes, in medical issues, etc. So how do you see this insurance industry taking a shape in future, and how do you think that mediation would be a part of this entire story as insurance industry grows, if at all it in your assessment is poised to grow?
Sure. Well, given the number of disputes that arise, I think, between insurers and the insurance companies, it's very common. And given the cost of litigation, I always think that mediation is always going to play a big role in resolving insurance disputes that all the parties, both the insureds and the companies, would prefer to settle these cases instead of taking them always to trial. My hope is that parties, I hope that parties start to mediate these insurance cases earlier
Hmm.
in the litigation life cycle. I hope that, going back to the case I talked about, right? It was two cases, one that was 3 days away from trial, and another one that I don't think the lawsuit had even been filed yet. It's my hope that more cases are like the latter one, that they're mediating much earlier, either early after the lawsuit's filed or pre-suit, right before the
Mhm.
lawsuit's filed. I think that would save the parties a lot of stress.
True.
It would definitely save them a lot of time. And I think they're able to get as good of an outcome and still a very good, fair settlement that they would be happy with.
And how much do you think is the awareness regarding mediation uh, between people in the US? Or the default setting is that they go for litigation and then they discover that there's something like mediation. How does it work out as far as awareness is concerned?
Well, the attorneys are obviously very aware of it, right?
Yeah.
All attorneys are aware of mediation. In terms of the parties, I think that'll depend on how sophisticated the parties are, right? If the
Yes.
insurance company is obviously very aware of mediation, they do it all the time.
Mm-hmm.
If you have a sophisticated insured, a business that's maybe had a lot of litigation, if you have the insured as a business that's also had a lot of
Yes.
lawsuits, they're probably familiar
Yes.
with it.
They would
If
know about
it's
it. Hmm.
Yeah, if it's a person, if it's an auto
Hmm.
owner, homeowner, they might not. There's actually a good
Yes.
chance they don't know what
Right.
mediation
Right.
is, or they don't know how it works. They don't know that it's available to them. And so
Mm.
in those situations, it's really up to the attorney to let them know, hey, we could, you know, try to settle this case now instead of taking it to trial. Mediation's obviously growing in popularity, but I wouldn't consider it common knowledge
Yeah.
among people who are not in the legal field. I think most people think that if I have a
Mhm.
problem, I file a lawsuit. I think that's more of
Yes. Yes.
the
Yes.
at least in the US, that's the mindset. And they're not
Mhm.
thinking, if I have a problem, I could mediate and settle it without
Right.
filing a lawsuit, or that I can
Mm.
mediate it at any time within the lawsuit. I think sometimes people think once you have a lawsuit, you're going to go to trial no matter what, which is also a reason why, for me and I think for all mediators, I think we're always very careful always try to do the best job we can, because a lot of mediators, we really do believe in the value of mediation, and we want to make sure it doesn't develop a bad reputation
Mm.
as something that's ineffective, that's a waste of time. That's what we don't want. And so I think we're
Right.
very careful
Right.
to do a good job and try to make sure the parties are satisfied, even if the case doesn't settle, that they're at least satisfied with the process um, that they went through, so that they're more likely to try mediation again, even if they try it once and that case didn't settle.
Can governments or the courts do anything in spreading this awareness? Because I think it's well within their domain that they can invite people for mediation. Are there any concerted efforts in the US about that?
Yes, definitely in Texas. There's, the courts. There's a lot of judges that can just order a case to mediation, saying, "I
Okay.
want you to mediate this case,"
Okay.
saying like it's required. There's some courts where they don't, where they say the parties are required to mediate,
Mm-hmm.
give them a deadline.
Mm-hmm.
Um, but then sometimes the parties don't, and there's not really I mean, it's probably different for each judge, but sometimes the parties can just not mediate. And so it is definitely encouraged in general by the courts. I think it's
Mm-hmm.
to varying degrees. Some judges might really favor it, others might not. But interestingly, mediation, it's all about, right, voluntary process. We learn,
Right.
self-determination of the parties. And I know sometimes parties will get ordered to go to mediation, and one party doesn't want to mediate, right?
Right.
They're only doing it
Right.
because the judge said they had to. Um, and that's tricky. It can get the mediation started off on the wrong foot, because mediation is set up with people are coming together voluntarily saying, we think we want to settle, but we're looking for some assistance. So when when one of the parties is being ordered to it, they're already coming to mediation, not really in a kind of a settlement mindset and a
In a mindset.
compromise mindset. They're saying, I
Mm.
was forced to come here. I don't want to, I hate the other side. My case is great. Just let me go to trial.
Right, exactly. This is happening in India also, because in India we have the Commercial Courts Act, and under Section 12 capital A of this act, we have a compulsory pre-litigation mediation. So you cannot file a suit unless and until you have been in mediation before. So the aspect of self-determination is, like you said, that one of the parties may not feel like mediating, or both of them may not feel like mediating, but then they have to go through the process, and that is rendering this scheme, it is not that effective as it is supposed to be. So maybe I think we are at the teething stage as far as mediation is concerned globally, not just in the US, but even in India also. Now it is picking up very quickly over here. And there is a lot of discourse on not just having mediation in the courtrooms or in a formal setting, but also going to the grassroots, making the knowledge about mediation a common knowledge. So there are lots of efforts happening in that direction. So let's see where things go. We'll have to wait and watch. But I would like to thank you, Jason, for your time. And all the insights that you have shared are very, very valuable. And I'm sure that there are multiple lessons. Although we have kept our discussion on insurance, it is insurance centric. But in general, as far as mediation is concerned, and as far as the nuances of mediation is concerned, people would be learning a lot of things from this podcast. So I thank you with all heart for giving your time in the early morning. I believe 8:30 a.m. in the morning is,
Yes.
it's not easy to get up and just do the podcast. So thank you for that, Jason.
No, no, thank you so much. Thank you for having me. I really enjoyed this. It's great. It's great speaking to you about this. And yes, I hope the listeners are able to take away some helpful information for sure.